Hey, this is Politics with Laura. Oh my goodness. Today, Fanny, she's there. She's there. Yes, yes, yes. She's there. Her daughter. Forgive me. Lawyer will speak. For Fanny to make that kind of money, and I believe to some degree, and she said to some degree that she kept cash. But she is, please keep this in mind. She is a public official in a very high office. She's an elected official by the people, receiving funds from the people. We can't forget that. She gets paid by people from Fulton County, from Georgia, whether if it's a local level and a state level, she gets paid from them. And if they say, did you receive a gift, $100 or more, and that right there to stop the corruption, that's why everybody's running from Florida. They have broke camp, gone. Everybody's resigning because they don't want to sit there and write down whom is giving them what. And it will be very interesting to see how they pose their policies and who the policies benefit and who the policies do not benefit. But I digress. Let's get back to Fanny. Okay. I'm sorry. I didn't mean to go on a tangent. Oh, man. Oh, here she comes. Fanny is coming. Oh, this is going to be good. Now, right next to her is her lawyer. I really don't know that gentleman's name. I should know it, but unfortunately, there's so many people that I have to know their names. And it's a lot of people, 18 people coming after her. But that's what happens when you indict 18 people and you don't have... What Fanny did was dumb. Okay, let me hold on. Just hold on for a second. I'm not saying that what Fanny did not inviting, but indicting Trump and 18 people. If she thought that she had a case, fine. She thought that she had a case. What I'm saying that is dumb is that her special prosecutor has no experience on this level. That is dumb. And that, I'm going to leave it right there. Right there. I'm going to leave it right there. All right. She's too smart for that. She's being overly nice. Not coming with her hand on her hip. Giving all that sass and attitude. She looked quite humble. She looked humble and smiling. Okay, let me move ahead a little bit.
I can share my screen.
We need to add you as a host then. What's your profile name on the Zoom? Your screen name on the Zoom.
Adam Abadi.
All right, just making sure. Bear with us. Do you need it right away?
No, I can start without.
All right, floor is yours.
So good afternoon, Your Honor. I want to start with some of the things that were addressed over the last hour and a half. First, beginning with something Mr. Merchant referenced as it related to the comments that the state made in regards to the good faith basis in which was submitted to the court, in which defense counsel claimed the evidence would show. And I would strongly bring to the court's attention that the claims that were made were material misrepresentations. And what I will say to the court, and why I say that to the court, is because the representations that were made by counsel was that Miss Daisha Young, Miss Sonia Allen, Mr. Dexter Bonds, Investigator Hill, Investigator Green, Investigator Ricks, all of these people would be called, and Mr. Bradley would be able to impeach their knowledge by saying that he specifically, in his presence or to him, said that Miss Willis and Mr. Wade were in a romantic relationship, and that Miss Willis and Mr. Wade were cohabitating, that they all knew that. And I would submit to the court, we didn't hear from any of those individuals. Mr. Bradley impeached no one. And I say no one because he did not impeach Mr. Wade. In order to properly impeach a witness, you have to confront the witness with the specific statements. Mr. Wade, and you can look back at the YouTube of the entire hearings of the last couple days, Mr. Wade wasn't once confronted with a statement that he claimed or said, or that is claimed that he said to Mr. Bradley. The way you properly impeach somebody, you have to confront the witness. Here would be Mr. Wade, and once he makes a statement that you believe to be inconsistent, and you have a witness who can prove that inconsistency, that's when you call that witness. And when Mr. Wade was on the stand, not once was he asked, did you tell Mr. Bradley this in a confidential conversation in your conference room that was not covered under attorney-client privilege? That was not asked. The specifics of that conversation was not asked. So any testimony that Mr. Bradley testified to is impermissible. It is improper impeachment because they did not confront Mr. Wade with it. So that's where the state would begin with the comments that Mr. Merchant made about me referencing his wife as lying. I never called Miss Merchant a liar. I never used those words. I don't know why she made the material misrepresentations. It could be because Mr. Bradley lied to her. I don't know the reason. So, but I can submit to the court that those were material misrepresentations that were made to this court on the day a few Mondays ago, as everyone was arguing the motions to quash certain subpoenas. I'd also bring to the court's attention that during that motion to quash subpoenas, certain subpoenas, Miss Yurdy's attorney appeared, Mr. Partridge, and he made very clear on that Zoom that Miss Yurdy had absolutely no knowledge of a romantic relationship and absolutely no knowledge of cohabitation. Those were the specific references that he made. So what I would submit to the court is those are considered adoptive omissions that his client has made based on the statements he made because of the representations she made to him. So, and I know that sounds convoluted, but what I would say to the court is Miss Yurdy told Mr. Partridge, because Mr. Partridge told the court that she had absolutely no information about a romantic relationship, and she had absolutely no information as in regards to...
So, but wait, are you making an argument I should make inferences based... Now, these would be attorney-client privileges, or communications then. She's communicating with Mr. Partridge about what her upcoming testimony is. That's why she's hired him, and you're telling me I should infer things based on her communications to him?
Absolutely, because they're not attorney-client communications anymore when he discloses them to the court and everybody else as they watch the Zoom and attend the hearing. The difference is there was no request to go in camera. There was no request to go or to have a private conversation with you as was done with Mr. Bradley. That would have been the proper procedure. So yes, I'm asking you to infer that, 100%. I'm asking you to infer that her testimony was at best inconsistent. Because the testimony of Ms. Yurdy, when she testified, was vague, very little description. When asked in a very leading manner, is it true, or do you know that Ms. Willis and Mr. Wade were in a relationship from 2019 into the time you were fired, you were forced to resign from the district attorney's office in March of 2022? She said yes. And then further, when pressed by Mr. Sadow, he talks about why she believed they were in a relationship. And what was interesting from Ms. Yurdy's testimony, that they were pretty close friends up until she left the DA's office, that she asserted to the court that on a yearly basis, Ms. Willis said, I'm in a relationship with Mr. Wade in 2019. Oh, by the way, I want to tell you again in 2020, because we're in a new year, I'm still in a relationship with Mr. Wade. And again, in 2021, the assertion is Ms. Willis then went back to Ms. Yurdy and confirmed, hey, I just want to reconfirm me and Mr. Wade are still in a relationship. It's absurd. It's absolutely absurd. More importantly, when Mr. Sadow asked her about why she believed that they were in a romantic relationship based on her own observations, she said something. He actually asked her, did you see him kissing or hugging? She said yes, but there was no description or qualification about when it occurred, what she actually saw, excuse me, was it a kiss on the cheek, things of that nature. So I would ask you to frame her testimony from that standpoint when you're addressing her credibility, as the court is going to do with each and every witness that you heard during the testimony of all the witnesses during the hearing. I'm going to see if my screen will share.
That's quite interesting.
I want to talk a little bit about the standard and the burden here in this instance as it relates to defense counsel and the claims that they have made in the motion to disqualify. And as I was doing a whole lot of research, I came upon this law review article from Cornell scholarship reading or publication, and they made very clear that courts have been relatively reluctant to exercise their power to disqualify prosecutors for any reason. And that goes along with the standard what the state would submit to the court is that the defense has to show an actual conflict. And in this instance, they have to show the actual conflict would be that Ms. Willis received a financial benefit or gain and did it got it based upon the outcome of the case. It doesn't make any sense. It makes absolutely no sense. And during the 3 days of the extensive testimony of all of the witnesses and the prolonged examinations of the witnesses by multiple of the defense counsel, they still got nowhere. We're in the same position we were in on Monday. The same assertions that were made on Monday have no answers today as we're before Your Honor. They were not able to provide any evidence as to, or to the contrary of Ms. Willis and Ms. Wade's assertions of when their relationship began. There's absolutely no evidence that contradicts that the relationship did not begin later than or around March of 2022, Your Honor. I'd further submit to the court because of this failure that their assertion or their request that one, the indictment be dismissed. There's absolutely no evidence that the defendants in this case, their due process rights have been harmed in absolutely any way. There was zero evidence. Not a single shred of evidence was produced through any of the exhibits or the witness testimony showing how their constitutional rights, their due process rights were at all affected by the relationship that began in March of 2022 with Ms. Willis and Mr. Wade. And because of that, the motion to disqualify should be denied, and Ms. Willis, as the district attorney of Fulton County, and Mr. Wade, as the special prosecutor assigned to this case, should be allowed to remain on this case and continue to prosecute the case to the end, Your Honor, until the trial is set by the court and is to begin. Now, the issues, obviously, you've heard a lot from defense counsel as to what the issues are for you to, I guess, determine. And here it would be the state's contention is that you must find that there's an actual conflict if you were or are to come to the conclusion that you should disqualify Ms. Willis and the district attorney's office. And looking at And what?
I think you're talking about, is this Ventura?
It's McGlynn v. State, McGlynn v. State, 342 Georgia Appeal 170. It's a 2017 case. In that case, as it talks about the standard of proof that the defense, or the burden that the defense must show and go to show an actual conflict, is they say it's a high standard of proof, which is definitely not a preponderance of the evidence, which is a much lower burden for any party who's trying to meet that standard of preponderance. But it's clear that the standard is that is a high standard of proof for both when determining whether there's an actual conflict and when there's forensic misconduct that is found, Your Honor. And I want to go through some of the cases that defense counsel has referenced as they argued here today and in their filings. And I guess the bright line standard, or the standard and the grounds for which disqualification is appropriate for Your Honor to be determining in all of the cases as it relates to disqualifying the elected district attorney, is you either find that there's a conflict of interest or that there's been some sort of forensic misconduct. Those are, I guess, the two areas that Your Honor that is in your purview when you are looking to resolve an issue regarding disqualification. Now, in a recent case, Lee v. State, which is 224 Georgia, Lexus 31. It's a February of 2024 case here out of our appellate courts. And in that case, Justice Pinson wrote that a trial court did not abuse its discretion by failing to disqualify an assistant district attorney absent an actual conflict of interest. And that is a case that was ruled on by the Georgia Court of Appeals about a month ago, Your Honor. Now, the cases in which defense counsel have relied on in their briefs and here today, I would submit to the court the cites are misleading, many of them are inapplicable, and some of them actually support the state's position. And what I would say to you is that the defendants, in many instances, combine language from the multiple cases and kind of what I would say is misstates the law as it relates to what the law or what is required in order for an elected district attorney and their office to be disqualified. And what I would submit to the court is...
Let's go back to that. Show me how.
Yes. Show you how.
So I think the first one they cited was Battle versus the state. Certainly a conflict of interest or the appearance of impropriety would be the grounds of disqualification.
Well,
there are a number of these cases that seem to exclusively rely on the appearance of impropriety.
right.
Well, they acknowledge that there's some ambiguity here, that sometimes Whitworth gets cited to Ventura, and we've got this quote that comes up where it's just they only cite to an actual conflict that must be involved. They acknowledge the ambiguity. You're saying there's no ambiguity whatsoever.
I am saying that, and why I am saying that, why I would submit that to the court, is in all of those cases, they do reference the appearance of an impropriety, but they reference that because they also find there's an actual conflict in each one of those cases.
So your position would be, your review of the case law, there's never been an appellate opinion that relied only on an appearance of impropriety.
As it relates to a prosecutor or a district attorney, yes, that is what I'm saying. What I would say is in those cases, they do reference the fact that there is an appearance of impropriety, but they reference that fact because when you have an actual conflict, there's always an appearance of impropriety. And those are what those cases stand for. And I guess that is the main example of what I reference as they kind of combine the language from separate and different cases and tell you that the standard is an appearance of impropriety. And I would submit to the court that is not the standard. And in my first reading, like Your Honor, I did notice that the cases each reference the appearance of impropriety, but also that that appearance arose from the fact that the court found an actual conflict in each one of those cases. So I won't belabor the point in going through all of the cases that the defense had cited, but what I would submit to the court in reading those cases is that I found that they kind of fell into 5 categories, that some that didn't concern disqualification at all, some that determined or that were about, I call it divided loyalty, which is a conflict that arises from representing becoming a prosecutor and then having represented the defendant prior to becoming a prosecutor, and then whether there's an actual personal interest in the outcome, and then others talk about whether the defendant was denied a fundamentally fair trial at the conclusion and of the case after conviction. And these are some of the cases that defense counsel had cited within their brief that had absolutely no application to the issue that we're here before Your Honor today. The first, McIver v. State, has nothing to do or has nothing related to the disqualification of anyone.
I mean, I think some of these are just relating to kind of aspiring for broad language about standards to prosecutors. So point taken there. But if they're more... All right, keep going.
So as it relates to one of the cases that was referenced here earlier and is also referenced in some of the briefing by defense counsel is the Regested v. State, which is 287 Georgia 542, and all of the cases that fall under this, what I would call category, is about a attorney who formerly prosecuted a defendant in I guess the same type of case or the same case or similar charges, and that would be why the courts the courts found that disqualification would be necessary because of the relationship that existed between the former client and the now person who's being prosecuted, Your Honor. The next series of slides just goes through what has been addressed as it relates to the standard that is required when dealing with the issue of disqualification, and the state would contend and submit to the court that the defense must show an actual conflict in order to have the district attorney disqualified, and that actual conflict has to be in the form of showing that Ms. Willis, in this instance, received a financial benefit or gain in relation to the outcome of the case. Like many of the cases that involve personal interest, Your Honor, it's all based on a contingency fee, where how much they're paid, or a bonus, for example, is dependent upon the outcome of the case. That's how one is to show that there's a personal interest in the case. We have none of that here. And I would submit to the court, we have absolutely no evidence that Ms. Willis received any financial gain or benefit. The testimony was that Ms. Willis paid all of the money back in cash as related to the trips, and if didn't pay back in cash, it was
all right. Let me explore this one a little bit. Mm-hmm. So, in addition to you're saying it's only an actual conflict, are you also saying that it's only if a financial interest is affecting the final result, the outcome? That's the only one we should be worried about? Or is it that the prosecution as a whole is what we should be looking at in terms of a stake? So what I'm thinking of, I'm just going to try and come up with some hypos here. What if ADAs are given a bonus for every motion to suppress they win, $1,000 per Fourth Amendment claim they win? Well, now they've got an incentive, if one of their officers is lying, not to tell you about it, because they want to win that motion to suppress. But maybe that doesn't affect the outcome, because you can win a motion to suppress or lose it, and that doesn't decide whether it's going to be a guilty or not guilty verdict. But doesn't that affect the prosecution of the case, if not the outcome?
Yes, I would definitely agree that that would be an instance where disqualification would be necessary and appropriate, because it's it's a situation that involves a contingency fee, and I would submit to the court that it actually does end up affecting.
It could, based on how important the motion to suppress is, right?
Right.
But if it's some immaterial, I don't know. But I guess, so you're saying it's maybe not so much just the whether it's a guilty or not guilty dismissal, no pros at the end of the day. It is actually the conduct of the prosecution that should be looked at throughout the course of the prosecution.
Correct, as it relates to how it affects the prosecution, which I would submit to the court ultimately is going to affect the end outcome of the case. If you have a contingency fee based on winning, or how, if you win a motion to suppress and if you win, you get, a bonus, as Your Honor referenced. I think that is ultimately going to affect the end outcome of the case, because as Your Honor just said, if there's an instance where an officer is lying, or that where there isn't a good faith to go forward with that motion, the prosecutor would go forward with regardless because of the contingency fee, which not only affects the prosecution at that point of the proceedings, but ultimately is going to affect the entire case, because if they were to win a motion to suppress, or I guess the motion would be denied and the evidence wasn't suppressed, knowing that they didn't have a good faith basis to go forward affects the ultimate outcome of the case. So I think it's twofold, as Your Honor has referenced. I think it's at that part of the procedure or the proceedings would definitely qualify for a reason necessary to disqualify a prosecuting agency, but ultimately that action during the procedure will lead to the ultimate outcome of the case being or hinging upon a contingency fee like the ones in the cases referenced by counsel and the state that are on the screen.
So getting into the language again, which you just had up there with greater amusements and amusement sales. Greater amusements is one of those. You refer to the appearance of conflict as dicta. Why do you think that's dicta? I think the quote from that one is, it guarantees at least the appearance of a conflict of interest. Why is that dicta? It seems very central to the holding in the case.
Because I don't disagree with Your Honor, but in that case, an actual conflict was found, and the appearance.
They didn't find that.
I would disagree with Your Honor. My reading of the case is that an actual conflict was found, but because of that actual conflict, an appearance of impropriety was seen, and that's the reference, or why the state referenced that case in relation to the argument that an actual conflict is required. In the series of cases, Young, that was referenced by defense counsel, as well as Nichols, these state are both instances where there's a personal interest in the case due to the situation and where at one point they were opposing parties. And of course, there's a personal interest or stake as it relates to prosecuting an opposing party in a civil claim, which are what both of those cases reference, which shows that there's an actual conflict of interest that relates to the personal gain of the specific prosecuting agency.
And what do you make of Nichols' reference to, it's an older case. Sometimes the language can be what we're not accustomed to seeing, but there's, they refer to the metaphor of Caesar's wife, and generally when that's used as a ethical standard, that's something that goes beyond just an actual conflict, right? Isn't the beyond reproach getting more into appearance world?
Is it getting beyond?
No, isn't getting into the appearance aspect of things when we're talking about Caesar's wife.
But I think it goes beyond that based on the language of the holding in that case, where it literally says that the individual had a personal interest in obtaining a fee by forcing a settlement in the civil case and using the criminal case as leverage. So that's not an appearance of impropriety. That is an actual conflict of interest, in which arises because of the individual's personal stake in the end outcome of the case, Your Honor. So that's how I would differentiate, I guess, the representations of defense counsel as it relates to the standard or the burden that must be shown, and why the state would submit to the court and the most recent ruling out of the Georgia appellate courts that an actual conflict is required to be shown. So I'm going to skip through these series of slides. You've heard all about Whitworth. So I go back to what we referenced earlier, what's been referenced by all parties, that the grounds in which a district attorney can be disqualified is where a conflict of interest is found, and where there's forensic misconduct that is found. Those are the two grounds that are to be, I guess, are within the purview of the court as it relates to the issues here. And again, I go back to the most recent case that was Justice Pinson wrote about, and that there must be, that by failing to disqualify the assistant district attorney absent an actual conflict of interest. I think the language there is very clear, and I think it's very controlling, and I think it's purposeful, I would submit to the court, because an actual conflict of interest is what is required in order for a district attorney to be disqualified, because the cases make very clear, and through the precedent relating to this issue, that a disqualification of a district attorney is the last, for lack of better words, ditch effort that should be exercised as it relates to the court in curing certain conflicts that may arise. I think the case law is very clear that every effort is supposed to be made instead of, or I guess in lieu of, disqualifying the district attorney unless an actual conflict of interest is what's found, Your Honor. And it can't be cured. So what I would reference to the court, as was brought up earlier in Lyons v. State, 271, Georgia, 639, a 1999 case where it talks about a theoretical or speculative conflict will not impugn a conviction, meaning that speculation, conjecture, things of that nature, assumptions are not enough for anything to arise to an actual conflict. And what I would submit to the court as well, that goes to the fact that what has to be shown is an actual conflict. If it's speculation.
Is there any qualifier there, though, that's in a post-conviction context? So we're talking about, competent evidence. We're obviously in a pretrial phase here. I've wondered how much import to give that sentence when we're in a pretrial realm. That's assessing whether to overturn a conviction, and usually that's kind of an entirely different standard where we assess as a totality: was there a fair trial? Is there harmless error? I know there's no harmless error when it comes to disqualifications, but just a thought, if you have any reactions.
Well, I think what Your Honor just said is pretty on point in the sense that if it's found that if the trial court either applied the wrong standard or should have disqualified the district attorney, it leads to an automatic reversal, like you said, and it goes back to the trial court. And I think that is very enlightening in the sense that that's only done if an actual conflict is shown, and the fact that it can't just be theoretical, speculative, or assumptions that would lead to the appearance of impropriety, the appearance of a conflict that would lead to
I guess when I'm borrowing kind of from, as we've been doing in the other pretrial motions, special demurrers seem to get different treatment pre-trial and post-trial. Post-trial, they get more of a pass unless you can show some issues, and I'm wondering if that same principle applies here with disqualification.
Well, and but
I don't have the answer to that.
Well, what I would also say, and I don't remember the exact line, but I know there in Judge McBurney's order, he does address some of the concerns as it relates to the standard as it is applied post-conviction versus pre-trial during pre-trial issues. And what I would say to the court is that.
So you're citing that in support? Because I didn't think the state was all that pleased with the analysis he applied.
Well, what I'm citing.
Legal analysis, that is.
Well, I'm citing what you specifically referenced as to the standard that is to be applied pre-trial and post-trial, whether it makes a difference. And what I would say to the court is the answer is no, as it relates to the speculative nature of the allegations or the claims made by defense counsel as it relates to whether a conflict actually exists, Your Honor. What I can't do at the moment is point exactly to the page. At the end of the state's argument, I can give you the page number as it relates to Judge McBurney's order.
I think I know what you're talking about, the footnote where he references the appearance standard.
Yes.
All right, I'm
Right.
looking at it.
Further, in Lamb v. State, 267 Georgia 41, on page 42, it's a 1996 case where the court says, nevertheless, the conflict must be palpable and have a substantial basis in fact. A theoretical or speculative conflict will not impugn a conviction which is supported by competent evidence. Now, I understand as it relates to the post-conviction factor or the status of the case being in post-conviction based on Your Honor's earlier inquiry, but I would submit to the court that as it relates to the issue of disqualification, that the standard is the same whether it's post-conviction or pre-trial. In Bloomfield v. Bornstein, which is 247 Georgia 406, the 1981 case. In that case, it says the appellees have not shown us a case where a per se rule was applied to disqualify an attorney on the basis of an appearance of impropriety alone. The Georgia cases cited by the appellee do not stand for the proposition that a trial judge is authorized in Georgia to disqualify an attorney solely on the basis of an appearance of propriety, which further goes to the state's submission to the court that the standard is that an actual conflict must be shown, and that conflict that arises shows there's a personal stake of the district attorney as it relates to their personal financial gain that's being alleged. So in the case that's been referenced by all parties here today, Whitworth v. State 275 Georgia, Appeal 790 to 2005 case. In that case, it says Whitworth's complaints are largely based on speculation and conjecture. Applying any evidence standard to the record, it is clear that the trial court did not abuse its discretion in denying Whitworth's motion to disqualify Morgan based upon his personal interest in his conviction.
Aren't we past the speculation and conjecture aspect of this, though? I mean, the original and the core of the financial allegation was that there is a relationship and that money has changed hands. There's maybe still an open question of where the ledger stands, but I think it was conceded that that balance could run in one way or in the district attorney's favor. Is that contested?
Yes. What's not contested is that a relationship did develop between
and that purchases were made back and forth. That's the state's position.
That is the state's position, but they were made back and forth. The purchases were made back and forth either to equal the money that was spent by one party or the other, and if that wasn't done, cash was exchanged in order to equal the costs that were paid by either one of the parties.
Right. But that's a facted issue, whether it was, split even, or whether it goes a little bit one way or another, or whether it's all the way $10,000 one way or another. That's a fact and issue as a result of the hearing, but it's no longer just the theory that money changed hand is no longer speculation or conjecture.
Well, I agree that money actually changed hands is not speculation and conjecture, but whether that money that changed hands had any financial benefit or gain to the district attorney, that is all speculation and conjecture. I would submit to the court. Absolutely all speculation and conjecture to harass and honestly embarrass the district attorney based on some of the questions that were asked that had absolutely nothing to do with the proceedings that we were here. For example, the lien on her alleged house, that was highly irrelevant, had nothing to do with the proceedings and the exchange of money between the district attorney and Mr. Wade. And the point of that line of questioning was to, again, embarrass and harass the district attorney in a way that was very public, and in a way that was to impugn her character as it relates to that line of questioning in front of the court, in front of anyone watching the proceedings as it unfolded. And the language in Whitworth, I would again submit to the court, requires that an actual conflict must be shown, which is why the reference to speculation and conjecture is again a reference, because speculation and conjecture leads to or equals an appearance of impropriety, not necessarily an actual conflict, which I submit to the court is what is required based on the case law. So in State v. Sutherland, which is 190 Georgia Appeals 606, it's a 1989 case, and it says, while the prosecuting officer should see that no unfair advantage is taken of the accused, yet he is not a judicial officer. Those who are required to exercise judicial function in the case are the judge and the jury. The public prosecutor is necessarily a partisan in the case. If we were compelled to proceed with the same circumspection as the judge and jury, there would be an end to the conviction of criminals, which goes to the premise that the appearance of impropriety is to apply to judges, not prosecutors. Because if that standard was to be applied in the manner in which the Sutherland case is referencing, then there would never be a criminal prosecution, because the state is always going to appear biased as it relates to getting justice for the victims or righting the wrong as it relates to the crimes in which the defendant is been indicted or accused of. So I want to move into I guess the evidence that Your Honor saw and heard during the last couple of days, 3 total days of testimony as it relates to the witnesses. You heard from Ms. Yurdy, who the state would contend is a disgruntled former employee. You heard from Terrence Bradley, also someone who is a disgruntled former partner. The text messages in the state's opinion show that he is vengeful. You heard from his own testimony here sitting before the court that all he did was speculate, and any information that he had and garnered and then passed on to Ms. Merchant was mere speculation. I believe he said that over and over again when asked if he had personal knowledge. My recollection is around 15 times he said he had absolutely no personal knowledge of a romantic relationship between the DA and Mr. Wade. You also heard from the special prosecutor, Mr. Wade, a former judge. You heard from the 80th governor of the state of Georgia, Roy Barnes. You heard from the first female elected district attorney of Fulton County, and you heard from her father, who was a 40-plus year practicing attorney in good standing when he left the practice of law. And what I would submit to the court is that Ms. Yurdy's testimony was nothing more than inconsistent at best, based on what I referenced to the court earlier as it relates to the representations that were made by her counsel prior to.
Are those in evidence? Would his responses during a motion to quash, which weren't subject to cross-examination by defense attorneys, weren't even part of the evidentiary record of the hearing? Again, I'm just kind of puzzled by that. You didn't ask the question of Ms. Yurdy, what did you tell your attorney before coming here? And then we could have dealt with privilege issues and whatever else.
I would agree with the court. It's not in evidence, but it was a statement by an officer of this court to the court during a hearing related to her testimony and how we would proceed with her testimony in this hearing. But it's clear that what was represented as to why she would not have, I guess, the inappropriate person to testify was that she had absolutely no knowledge of the romantic relationship. That was the basis of why her counsel was saying that she shouldn't have to testify, that she shouldn't be compelled by
under
the
that
court.
theory, if accepted, where did the incentive arise between Monday and Thursday for her to completely change things around?
Where did the incentive
So
arise?
she was fighting so hard to avoid the, if we're going down that road you propose, she was fighting to have, not to come in here and testify at all. And then she comes in here and testifies. Why would she have testified the way she did if she didn't want to testify so strongly? If we're going down this road of trying to just gauge her interests and these kind of things, I don't know if I'm quite following that theory.
And I can appreciate that, but I would say the reason she didn't want to testify, I would submit to the court, is because this is an incredibly public forum where she would have to testify against a former friend and a former boss. And I think the change, I wouldn't qualify it as an incentive. What I would qualify it as is ultimately when she was forced to testify, right, a motive and a bias as to why she testified in the manner in which she did. When asked by Ms. Merchant as to the reasons for her leaving, she kind of danced around the issue. And then as Ms. Cross asked her about whether she resigned or forced to leave, she was fired, she came out and said she was given the choice: you can either resign, but either way you're leaving. You're fired, or you can resign in a manner in which, she wouldn't be officially fired, and when she's trying to get future employment and things of that nature. So I would submit to the court that there's absolutely no incentive. An incentive is not why Ms. Yurdy's testimony changed, or the state would contend her testimony changed, but it was the reason she testified the way she did was because of her bias towards the DA, which gave her motive to what the state would contend is be less than honest before the court. And I would.
But if we're going to draw inferences based on her fighting the subpoena, why would she have fought it if she had such a bias and wanted to say these untruths?
Because she didn't want to come on national television and have to be exposed to the things that, well, I don't know anybody who wants to testify before a court in a normal trial, a normal proceeding, but one of what I would qualify in this high profile of a nature where everybody would be able to watch and learn at what she has to say as it unfolds in the courtroom. And I'd further submit to the court there is reference to she left the DA's office in the text message that were submitted in, I believe, what is it, Defense Exhibit 39, that it's because she released confidential information in the DA's office, from the DA's office, that led to her firing, that she wasn't.
And I know I'm just because it's more conversational, which I appreciate. I know I might be getting you off script, so I don't want to use up all your time if you need to get through some other things.
Next, Terrence Bradley, and I believe the one thing that the state and defense counsel can agree on, that he was less than honest at times during the proceeding and during his testimony. He, when pressed or asked by Mr. Sadow why he was fired, he basically chalked it up to a dispute between partners in a business. But when pressed by Ms. Cross, it was clear that that wasn't the reason. And what I would submit to the court, what has been referenced by defense counsel as baffling as to why the state would go into such a topic area. The state, as all counsel has when appearing before the court, has a duty of candor. And when Ms. Cross knew she was going to have to cross Mr. Bradley, she knew he lied. And she had a duty of candor to the court, in the state's opinion, to expose that. More importantly, it goes to his credibility and the statements that had been represented by defense counsel that he allegedly had made in the past. So it was important to bring that to the court's attention, because when a witness is testifying, the court is assessing their credibility and determined to whether to believe the veracity of the statements made by the witness or not. So that is the most important factor when determining whether somebody is telling the truth or a lie. Furthermore, he reluctantly, when pressed, finally admitted that he paid off the assault victim. Eventually it started with an escrow account and led to he did pay off the victim in that case. He testified over a span of 3 days, and like I referenced to the court, he must have said 15 times that he had no personal firsthand knowledge as it relates to the relationship between Ms. Willis and Mr. Wade. More importantly, when pressed by counsel, he could not pinpoint a time in which he knew that the relationship occurred. There were many instances in which he described that very well could have fallen within the time frame that was testified and by both Ms. Willis and Mr. Wade as it relates to the relationship beginning or transitioning into dating in March of 2022 and into the end of the relationship in August or the summer of 2023. And as I referenced to the court, the statements that Mr. Bradley made, the state would contend are inadmissible hearsay as it relates to the statements that he was pressed and asked about what Mr. Wade told him, because Mr. Wade was never confronted with those statements. And in order for impeachment to be proper, he must be confronted with the specific statements that are alleged to have been made in order to impeach him. Again, Mr. Bradley had every motive to lie. I believe the text messages are kind of clear, are very clear as it relates to his disdain towards Mr. Wade, which due to the fact that he was expelled or exiled from a thriving law practice, and it was clear that the practice and Mr. Wade sided with the alleged sexual assault victim, which is clear he assaulted her due to the fact that he paid her off. And as I referenced earlier, Ms. Merchant represented to the court that Mr. Bradley had personal firsthand knowledge basically of it all, of everything, and that he would be able to basically be an impeaching machine. I think Your Honor referenced him as the star witness when you were addressing the claims that were made by Ms. Cross in relations to Ms. Merchant's representations to the court. And what I would submit to the court is that all Mr. Bradley's representations as it relates to whether or when the relationship between Ms. Willis and Mr. Wade began, and whether they cohabitated, because that was a promise that was also made, that he would be able to impeach the investigators as it relates to cohabitation, was mere speculation, gossip, and innuendo. And this is, Your Honor.
The impression I got, and we can correct this while we're all here together, is that Mr. Bradley directly overheard a statement from each of these individuals that they could be impeached with. Ms. Merchant, is that accurate?
Directly overheard. Which ones are we talking about specifically?
Well, essentially, that kind of seemed to be all of them. You had said Allen, Bond, Young, and then the investigators, Hill, Green, and Ricks, could all be directly impeached by statements overheard by Mr. Bradley.
Yes.
In reference to your question, the unequivocal answer was yes. And when Your Honor is looking through the text messages, I would submit to the court that the text messages don't even say or indicate what was represented to the court in relation to the good faith basis for this motion to disqualify as it relates to the testimony of and the ability to impeach witnesses through Mr. Bradley. What's been referenced by all counsel is Mr. Bradley's assertion of absolutely as it relates to whether the relationship existed prior to Mr. Wade's hiring. And the question in itself involves speculation, because it asks, do you think it started before she hired him? And he says absolutely. He doesn't say he knows. He doesn't provide any context as to how he knows. And in these text messages and through his testimony with the court, the source of his information was unclear. What I would say to the court, as to a lot of things, other than the one conversation that allegedly occurred between Mr. Wade and Mr. Bradley, and I would submit to the court that conversation never occurred. That would be the state's contention. And how do we know that? We know that because that conversation was not confronted, or Mr. Wade was not confronted with that conversation, and that is evidence circumstantially, and I'd even say direct, as to that conversation not existing. Because based on the representation made by defense counsel, it would be clear that that would be a conversation that would have been relayed to, because it wasn't privileged, as Your Honor found, that would have been relayed to Ms. Merchant. And if that conversation happened, you better believe that would have been a conversation that defense counsel would have confronted Mr. Wade with and against. And the reason they didn't do that was because it didn't exist. Again, you heard from Mr. John C. Floyd III, the district attorney's father. As Your Honor heard, he was a well-respected member of the legal community for over 40 years. But the importance of his testimony was to provide the court with corroboration as it relates to the years leading up to the relationship that transitioned into dating between the district attorney and Mr. Wade. What he testified to is that he moved into her South Fulton home in 2019. The evidence of his moving into that home at that time was his Georgia driver's license, official government document. He further testified that not only did it wasn't that just Miss Willis and himself live at the South Fulton home, but that he often would see on numerous occasions the significant other of Miss Willis that was not Mr. Wade. He referenced that that person had a nickname of Deuce, and that he kept a lot of his belongings in the garage of Miss Willis. He specifically said he kept a lot of his disc jockey equipment, is how he referred to it when before the court. He made very clear that he had never seen Mr. Wade at the South Fulton home that is owned by Miss Willis. He made clear that he lived in that home with Miss Willis and Miss Willis alone, other than her two daughters who would occasionally visit that home until after February of 2021. But what precipitated the soon move of Miss Willis to what I would reference as safe houses for her protection was a protest that occurred before her home in February of 2021. He then expressed to the court that Miss Willis moved in the spring of 2021, and that due to these threats that were taken very seriously, he had only seen his child 13 times. He said, in reference to the questions by defense counsel that were in a, and I'm just going to be straight up with the court, they were trying to make Miss Willis a liar, what is how I would submit to the court, in the sense that she testified that she was concerned for her safety and her family's safety, which included her father and her daughters, and that Mr. Floyd remaining in that home kind of rebutted all of that, made it so it wasn't true. But he testified that he stayed in the home because it was the home that she had put her blood, sweat, and tears in and was able to buy, and that he stayed in the home because there was constant officer presence. He told the court that he bought extra security equipment. He even went as far to tell the court that he slept in different rooms on different nights because he felt his safety was in such a concern. So I would submit to the court that line of questioning was done in an attempt to discredit Miss Willis, but failed. Would be how the state would characterize it. Then he testified about the first time that he did meet Mr. Wade, which is in 2023 here at the district attorney's office. And he talked about how he kept cash in his home and why Miss Willis kept cash in his home. And what I would, what the court should take note of is the state didn't ask Mr. Floyd about the cash in his home. That came out through the cross-examination of defense counsel. There was I guess, an implication that Mr. Floyd only did so due through his preparation with the state and his hearing and seeing news articles and clips related to the testimony that had occurred prior to him. But I would submit to the court that it's telling that that information came out through questions that were asked by defense counsel, which gives credibility to the statements that were made. And he further explained as to why he taught his daughter to keep cash in the home as it relates to financial independence and having a safety net. It was further testified that he had multiple safes and that he gave Miss Willis his first lockbox, or her first lockbox, for situations as she described when she was testifying. And what I want to make clear is during Ms. Willis's testimony, it was pressed about the cash and where she kept it, did it follow her, where she laid her head, and things of that nature, trying to further discredit the practice that she had as it relates to keeping cash in her home and why she had the ability to pay cash to Mr. Wade and other people and for other situations. And what the court should take note of is that there was no evidence that controverted that at all. Where was the evidence that controverted Miss Willis's claim and practice of keeping cash in her home? There was none. In fact, the only evidence is it was substantiated through the testimony of her father, Mr. Floyd. Furthermore, you heard from former Governor Roy Barnes, and his testimony was significant and important because how I would phrase it, Your Honor, is it debunks.
Let me on this point, and I think you might have had a more recent opportunity to review his testimony than I have. You say on the slide that she was the first choice to lead the prosecution. Was that actually his testimony, or was his testimony that he was asked to come aboard? Did he use the words that he was asked to lead?
Yes, it would be that's my recollection, that he was asked to lead the prosecution. He was asked to he was asked to fill the position that Mr. Wade is currently in, which is the lead prosecutor. It was said in that way as well as it relates to the testimony of Mr. Barnes. So I think it would be very clear. My recollection is that he said lead, but what I can submit to the court that I know he also said that he was asked to fill the position that Mr. Wade is currently filling for the state of Georgia, which is the lead prosecutor.
At that time, as special grand jury prosecutor, right?
Yeah, the special, I guess, yeah, as the special prosecutor, lead the investigation, which led to the ultimate prosecution that we're here before Your Honor today. He also indicated that the reason he turned that job down was because it didn't pay enough. He said he had mouths to feed at his law firm, and that he also didn't want to live the rest of his life with bodyguards because he had lived that for the years in which he was the governor of Georgia. Furthermore, he confirmed the qualifications of Mr. Wade, which I still find it quite interesting and confusing as to attacking Mr. Wade's qualifications, in that it's almost as if Mr. Roman's counsel is asking that the state put a prosecutor on the case that she sees to be more qualified to attempt to convict her client. It's an interesting argument, and it's one that makes no sense. Furthermore, if you were to believe the claims and allegations as it relates to Ms. Willis' personal stake in the prosecution, the receiving of financial benefits and gains, then you'd have to believe that she was also dating Roy Barnes, the former governor, and Gabe Banks, in addition to Mr. Wade. If she has this grand plan scheme in order to profit off of the prosecution of this case, because that's what they're saying. Or they're saying that she telepathically or prophetically was able to know that Mr. Barnes and Mr. Banks would turn down the position so she could then hire Mr. Wade. It's ridiculous. It's absurd, and it's desperate. It's a desperate attempt to remove a prosecutor from a case for absolutely no reason, Your Honor, other than harassment and embarrassment. This slide, and we've been through a lot of the testimony.
And I should be clear there, it was not introduced in evidence that Mr. Banks turned her down, right? How's that part of the record?
Well, I'd ask the court to take judicial notices, has been asked repeatedly.
Unless the district attorney had testified to that. I don't recall offhand.
I will be frank with the court. I don't recall if Ms. Willis testified to that exact fact, but I know that Mr. Banks represented that to the court during Monday's hearing as it relates to the allegations that were made. I understand Your Honor's position as it relates to that.
I'm just trying to make sure we know exactly what is in the evidence and is not, but regardless, I think your point is made.
I think it's an evidence of the record as it relates to, I guess, the issues that led up to the actual hearing of this case. So I understand Your Honor's position, but it did come out during a proceeding that was prior to the actual hearing. This slide is just a chart showing kind of the testimony of both the district attorney, Ms. Willis, and Mr. Wade, as it relates to how they met, how or when Mr. Wade became the special prosecutor, when their relationship evolved into a romantic one, talking about the trips in which they took after their relationship evolved into one that became romantic, and when it ended. And what, again, I would submit to the court is that those facts were consistent, and the only person who contradicted that when the relationship started was Ms. Yurdy. And what I would bring to the court's attention is that it was represented to the court that Ms. Yurdy was a witness other than Mr. Bradley who could bring to the forefront this issue of cohabitation. And when pressed and when asked about it, Ms. Yurdy had absolutely no information as it relates to this alleged cohabitation. It was false. She said she had no information. She was asked about trips. She said she had no information about the trips. Yet, she's such a good friend that Ms. Willis confirmed each year that Mr. Wade and her continue to be in a relationship 2019, 2020, 2021, until their relationship ended due to her forced resignation and splintering of their friendship, Your Honor. I guess several exhibits obviously were tendered in. Most of them were exhibits that came from the sealed divorce of Mr. Wade and Ms. Jocelyn Wade, contracts for legal services, trip itineraries, and the text messages. And I would specifically reference prior to today, the only text messages that were before Your Honor were defense exhibits 26 and 27, which it's the assertion of defense counsel that what those show is that Mr. Bradley had information as it relates to the relationship starting prior to March of 2022, and that's just false. Those text messages do not contain that. It does not pinpoint, just as Mr. Bradley couldn't, when the relationship actually started. And furthermore, you have the testimony and the evidence of the text messages that it was mere speculation. If you, as Your Honor reviews the full chain of text messages, it is clearly Ms. Merchant and Mr. Bradley going through what I can describe as nothing else other than a mere fishing expedition between the two of them at first, because it's asked about certain members of the DA's office who would have information as it relates just specifically, for one, Ms. Young. It is asked whether she would have information, and he had no idea. He said he assumed, he was speculating. And that is the same as each person that was subpoenaed in reference in the text messages. All of that was speculation. And you know it was speculation because not a single one of them testified. That's telling. Because if it wasn't mere speculation, if it wasn't mere gossip, and if it wasn't mere conjecture, each one of those people who were subpoenaed would have been called to testify, like District Attorney Willis was, like Mr. Wade was, in order to be confronted and then impeached by Mr. Bradley. You've heard, obviously, about the phone records, and I have a maybe, because whether it comes into the purview of Your Honor as it relates to the determination Your Honor is to make as it relates to the disqualification of the district attorney. You also have the affidavit from the employee who worked at the winery who confirmed that Ms. Willis did, in fact, pay in cash up to more than $400. And I understand that this is part of the proffer of the state, but it's important because that is a witness who the state didn't go find. That is a witness who went to CNN in order to confirm what Ms. Willis testified to, further giving her statements credibility and credence before the court. You heard about...
Well, before we move on from that one, other than the foundational concerns, would you have a response to the proffer of the cell phone records?
I have, I'll get to that now. I was going to get to it later, but I have several foundational concerns as it relates to the cell phone records. I don't think I've ever, as Mr. Sadow's motion makes very clear, the state uses cell phone records routinely. And I would agree with that. We use them routinely, but we use them with an expert, and they're always challenged.
Right. So, like I said, in the interest of time, setting aside the foundational concerns.
Oh, I thought you were asking about
No,
them.
no, no. Focusing on the substance of them, assuming that it would be admissible in the guise that he's proffered. Maybe you have that further up, but what's the reaction to that?
So what I would say initially is that due to the fact that they were analyzed by someone who was a non-expert, the analyzation of those cell phone records were not properly peer-reviewed. They were not, it's clear from the state's review that the normal practices that are used to check the use of which kind of data is being used in reference to the two specific dates, I believe it's September 10th and 11th and November 29th and 30th, the affidavit that is used to say that Mr. Wade remains at Ms. Willis's or in the area of Hateville, because again, during the hearing, the address for the Yurdy condo never came out. It was just that it was the Hateville condo. The actual phone number for Mr. Wade was never established. And the documents that were provided to the state that were certified business records did not have a subscriber page. So we have no idea that the number belongs to Mr. Wade. Now, I understand Your Honor wants to look past the foundational issues, and I can appreciate that. But the foundational stuff is very important as it relates to the admissibility of the records.
No doubt about that. But if somewhere how they were able to survive those foundational concerns, do you have any reaction?
Yes, I do, and I will skip forward so I don't. So what's interesting is that the records that were provided they start in January of 2021, and they go, I believe it's to November 30th, I think is what of 2021, the span of the records. And you heard from all of the witnesses, including Ms. Yurdy, that Ms. Willis did not move into the Hateville address until April of 2021. That was the testimony from all of the witnesses, April of 2021, and that she lived in her South Fulton home from when she met Mr. Wade in October of 2019 up until when she had to move. And the assertion by defense counsel is that Mr. Wade and Ms. Willis began a relationship right after they met in October of 2019. What's interesting and what's telling is that Mr. Wade's handset doesn't once appear in anywhere near the area of her South Fulton home, but they're dating, but they're in a serious relationship. And if you were to believe what the defense counsel says, that they have been in a relationship from October of 2019 up until she moves in April of 2021. So, a year and a half or so, but he never once enters the area of her home. But they want you to believe that that's a lie, which is why counsel for defense continued to press District Attorney Willis and Mr. Wade as to whether he had ever been to that South Fulton home. Well, this corroborates that that was not a lie, that he had never been to that home, and it's more than suspect if you've been in a relationship, as they claim, for all this time, but never once went to the house. So I think that's telling. What I would also bring to the court's attention in the state's initial review of the records, that from January of 2021 to March of 2021, those times when Ms. Willis did not live, again, at the Hateville address, she didn't move there until April of 2021, that his handset appears in that area 23 times.
Sure.
Why
How
she's
do
not
you
living-
reconcile that with this testimony that was alluded to, I think, by opposing counsel, the reasons he gave for being in the area?
Well,
Would those line up to 23 times? I think,
well,
it didn't give you too many reasons for being there, right?
Well, I think that's the point. I would say yes, that is the point. He referenced that that's an area that it was not uncommon for him to be in, and clearly that is the case because Ms. Willis didn't live in that area. So again, it's further corroboration as to what Mr. Wade indicated to the court. And after Ms. Willis moved into the condo in April of 2021, they appeared 35 times. Now, I want to make clear to the court, both Ms. Willis and Mr. Wade never denied that he had been to that condo before. The specific testimony that was elicited by Ms. Willis and Mr. Wade was that he had never laid his head, was the direct quote, at that condo, which these records don't prove that he laid his head anywhere. If you were to believe the analysis, or if you were to give credence to what the non-expert says as it relates to Mr. Wade's handset in September and November for the 3 to 4 hours that the phone is alleged to have remained, that doesn't disprove anything that was testified by both Mr. Wade and District Attorney Willis. It was that he visited there. The specific hours of their visits was not something that was pursued during the questioning of both of the parties. So what I would also submit to the court is that if you look at the days as it relates to in September and November, the use, the type of information that is used to make the plots for the longitude and latitude of the handset is data records. It's not voice records. It's not SMS or text messages. It's data records. And it is not uncommon for an expert to testify as it relates specifically to AT&T records that actual data record is unreliable as it relates to the location of the handset due to the type of information that it is, that it's data. It's not the voice and the SMS, which I know, Your Honor, as has been referenced, was a prosecutor not only here in this county, but for the federal government, where this kind of information is commonly used. So in the comments that were made by the court, it was clear that you understood and understand the use of cell phone records as it relates to put somebody in an area, and again, not in a specific location. I'd also bring to the court's attention, as it relates to the validity of the affidavit and the analysis done by the expert that was hired by Mr. Sadow, is that not once does it reference the fact that AT&T records commonly have duplicate and triplicate entries within the call detail records. That is something that is commonly seen, and that is something that is seen in these records. And that is something that leads to the incorrect number of times that has been alleged that Ms. Willis and Mr. Wade were in communication through text and voicemail. And I'd also submit to the court that that number doesn't prove anything again, doesn't prove that anybody's in a relationship. It proves that they were in communication with each other. And I think Your Honor can use your own life experience as it relates to people you work with or friends that you are close with, and the number of times that you make calls to any of those people. I can submit to the court that I have a friend who I have been friends with for 15 years, and she worked in the office previously with me, And based on our professional relationship and our personal relationship, the friendship that we had had and still have, that we talk 30 times a day. So and that doesn't mean we're in a relationship. So the assertion that the number of times that Miss Willis and Mr. Wade have spoken to each other, whether it's through text message or phone, it has no validity as it relates to them being in a relationship. What I would submit to the court is that what was shown through all of the evidence was that there's been a true cost to Miss Willis as it relates to her life, that she had additional expenses that she had to endure because of her position, in the sense that she told the court that she had a mortgage, but on top of that mortgage, that in a house she didn't live in anymore, she had to pay for a safe house, that her home was vandalized, and there were racial epithets and sexual bigotry that were spray painted onto her house. The concern of her safety in her life is something that was testified to, and the fact that this job has led to the isolation and separation of her from her family and friends, which was given credence, and the credibility of those statements were provided by her father, Mr. Floyd, that he had only seen his daughter 13 times since all of these instances occurred. The cruel nature of the statements and the falsehoods that, for example, in these text messages that were purposefully leaked to the media as it relates to Miss Willis's daughter, subjecting her position in school, that she flunked out of college, which isn't true, which in fact she has graduated from an HBCU. But what's been leaked to the media is the fact that she flunked out of school and someone other than her father moved her, which again, the validity of which was never shown. And all the while, Ms. Willis, facing these costs, has been able to continue to do the work unrelated to this case, which is shown in the fact that Atlanta's murder rate and violent crime rates have decreased while she has been in office. What was shown through the testimony of all of the witnesses and through the evidence that Your Honor heard was that there wasn't an actual conflict, that the defense failed to provide any sort of actual conflict in relation to Ms. Wade's, I guess, the relationship that transpired from the relationship between her and Mr. Wade, and that there was absolutely no evidence of a financial benefit that she gained as it relates to the prosecution of this case and the ultimate outcome of the case. The corroboration of all of that is the things that Your Honor is very much aware that she could have, I guess, financially benefited from, stretching out the case, for lack of better words, by the special grand jury recommended that 39 individuals be indicted. But through her sifting through the special grand jury's report and all of the evidence with the team that indicted the case, they only went with 19 of the defendants, which had she gone with all 39, based on the defense counsel's assertions, would have given her the opportunity to certainly find these financial gains that are claimed through the allegations of defense counsel. More importantly, why would Ms. Willis repeatedly ask this court to set a trial date as soon as possible if her motive in prosecuting this case was to continue to financially gain, as alleged, from the prosecution of this case? It doesn't line up. It doesn't make sense. And it doesn't make sense for a reason, because it doesn't exist. More importantly, this office has multiple RICO and as well as large-scale cases like this one, and much larger. And they also there's a lot of high-profile prosecutions. If Miss Willis's ultimate goal by hiring Mr. Wade was for her financial benefit, then she would put Mr. Wade on every single one of those cases. So she could certainly revel in the riches and lavish lifestyle that has been referred to by defense counsel, which there's been absolutely no evidence of. The evidence was she stated a DoubleTree in Napa, a DoubleTree. I don't know that to be a a lavish hotel. Most people, when they go to Napa, if they want to lavishly experience Napa, stay at the Ritz-Carlton, the Four Seasons, things of that nature, not a DoubleTree. So the allegations and assertions that Miss Willis was living the lifestyle of the rich and the famous is a joke, absolute joke. As it relates to what you heard, and the secondary issue is the forensic misconduct. And for lack of better words, what it has to be shown is that the statements that were made by Miss Willis related to the prosecution of the case and ultimately the guilt or innocence of the defendants. And we have none of those statements. There's been no evidence. Nothing has been provided to your honor as it relates to Ms. Willis' specific statements made about any of the defendants and in relation to the guilt or innocence of any of the defendants. I forget which defense counsel referenced the fact that she said she had a 95% conviction rate. Well, what Ms. Willis's job is to instill confidence in the community as to how well she is doing as it relates to her constitutional duties. And that was exactly what was done when she referenced that she had a 95% conviction rate from the previous year that she was serving as a district attorney. More importantly, it's been the allegations about race and religion being imputed in her speech, and those comments were directed at the defendants at this table. And if you listen to the speech, those comments are directed at two elected or political officials. I believe it was Marjorie Taylor Greene and Ms. Bridget Thorne, who is a member of the Fulton County Board of Commissioners here. She specifically used their names. I don't know that they, and my knowledge is they're not supposed to be sitting at the table, and I haven't seen them in my work as it relates to this case, Your Honor. So those allegations that Ms. Willis committed forensic misconduct are, again, there's no validity to them. There's no evidence of them as it relates to any of those comments, which this is an issue that Judge McBurney has previously ruled on when these same allegations were alleged as it relates to extrajudicial statements made by Ms. Willis, and it involved a statement that the words fake electors were said by Ms. Willis, and he found there was absolutely no conduct that was impermissible as it relates to forensic misconduct. And I guess to drive home the point, at no point in any of the statements that were made and that are alleged here as it relates to the speech that she made at the church, at no point did she mention the guilt or innocence of any of the defendants. She, again, was merely responding to comments made by Marjorie Taylor Greene and Bridget Thorne, two other political officials, therefore making her comments not even close in the realm of any sort of forensic misconduct. What I find interesting is that defense counsel wants to make these allegations that Ms. Willis committed this forensic misconduct by the statements that she made in her defense as two unrelated, in this case, public officials criticized the job that she was doing. And, I find the hypocrisy interesting in the sense that we've had video proffers released to the media by defense counsel, emails between counsel released to the media by defense counsel, statements have been made by defense counsel in relation to this case. We had the unredacted version of the cell phone records of Mr. Wade released to the media by defense counsel with his private and personal information causing the threat of harm to both Ms. Willis and Mr. Wade to increase. The most recent instance was the text messages that Your Honor hadn't ruled on their admissibility prior to their release, and it was made clear during the hearings that the ability to get those, the full chain was something that they were unable to do. But they figured a way, and the minute they figured a way, they released it, the information to the media, simultaneously with turning it over to the state and the court. For all all the reasons obviously stated before Your Honor, that this motion should be denied because the legal requirements that are required in order for the district attorney to be disqualified have not been satisfied. The defendants have failed to raise any issue legally or factually to satisfy the legal standard for disqualification. They must show an actual conflict. They've been unable to show that the prosecution of this case was at all a result of political bias, which has been accused, or accusations have been made, as well as demonstrated that the prosecution of this case was motivated by any means or any way because of malicious prosecution. And they haven't been able to prove that this case was one of selective prosecution for political benefit or gain. All allegations that have been made during the course of different hearings and the procedures as it relates to this case. What I would leave the court with and how the state started the argument is that courts have been generally unreceptive, if not hostile, to attempts to disqualify prosecutors based on pervasive and institutional conflicts, which makes clear that the burden, that the standard is very, very high that must be met in order for an elected district attorney to be disqualified. And that burden, that standard has not been met. An actual conflict has not been shown. And more importantly, in conjunction with that, there's been absolutely no evidence that the district attorney has benefited financially at all, but benefited financially in conjunction with any outcome, whether it be now or ultimately as it relates to the prosecution of this case. And because of all those reasons, Your Honor, we would respectfully request you deny defense counsel's motion to disqualify the elected district attorney, Ms. Fani Willis.
All right. Thank you, Mr. Abadi.
Wow. Okay, I have to admit, I wasn't expecting it to be that long. I wasn't expecting it to be over an hour in, 20 minutes, 30 minutes? I was expecting it to be 20 minutes. He laid out everything. Now, I gotta say, the attorneys who are going after Fani, they laid out an interesting case, a good case, but something that just popped out at me, and I don't know if everyone paid attention to it or not, but blue suede boots, that I call, and other people in the YouTube streets calls them blue suede boots. He said that they're to look at the appearance of wrongdoing. Not that she did anything wrong. No. Just the appearance, which is a very low bar. Not only he said it, but John Merchant not only co-signed, but he said it first, but Steve Sudo, he cemented it and really laid out a case and cited court cases to where it was simply the appearance of it. Now, Fani's attorney, I gotta say, he did an okay job. I mean, I wish that he would have. Okay. I don't know what I was expecting, but I think he did okay. He did okay. I think he could have done more. And I'll leave it right there. But he said that, what did he say? I tried to write it down. He was going too fast. Oh, no. Okay. Sorry about that. He said, number one, he stayed on procedure. Okay? He stayed on procedure and how things should be done. And he said the information, the data, the text messages going back and forth, it was not obtained in a proper way. It wasn't obtained properly, the data from the cell phone company. And then there was a gentleman, what was his name? That's neither here nor there. The gentleman's name that collected the information and used the data went through some sort of program. He was going so fast I didn't write it down. But he said he was not an expert. He was not an expert, and that in order to bring that type of information into the court of law, the person is supposed to be an expert in that situation. Now, the 18 clients all know, all of their attorneys know that you need expert witnesses for information like that, because as he laid out, that it doesn't give you an approximate location. It gives you a roundabout location. And anyone who uses Google Map, whenever you're trying to track your man or your woman on a phone using Google, you get a roundabout area. You do. It doesn't give you 1200 Peachtree Lane. No, it gives you an area in that community, a certain area. So I thought that was rather interesting. Now, also, he said, he talked about the due process, which she wasn't given. Now, blue suede boots. When he talked about the data, he did not present it in the way that it was supposed to be presented in Georgia, in Fulton County, to where you submit it and then you talk about it. And then you give the other side an opportunity to be able to say, yay, oh, this, blah, blah, blah. I'm going to try to defend this. I'm going to do that. I'm going to do, whatever they were going to do with the information. But that's not what he did. He gave the testimony. Fani and Nathan gave their testimony. And then he was like, are you sure November 1st, 2022? Are you sure it wasn't before that? Are you sure it wasn't before that? I'm sorry, November 1st, 2021. He kept on saying, are you sure it wasn't before that? He didn't submit it for them to say, okay, well, he has this data. He got it from Nathan's phone. Now, let's understand this. Logically thinking. If you're tracking someone's phone, especially a woman, okay, women, you're saying that, oh, he did this. I know where he was. He was there. I know he was there. I know he was there because I tracked his phone and the phone said he was there. But the interesting part was he didn't get Fanny's phone. He did not subpoena her phone to be able to show where she was when they said where he was. That, I think, they dropped the ball on that one, in my opinion. Because if you're only going to use his, you should also use hers to be able to cement that point. I know they were there together because his phone pung there, her phone pang there. Pang, pong. Okay, you know what I mean. They were there together at the same time in the same area, location where she lived. That's not what they did. Blue suede shoes, in my opinion, he should have went deeper on it. Just my thought. Now, also, let me see. I talked about the conflict. Oh, the conflict. Now, what he's saying is that, well, they're talking about the substantive conflict, and that's a low bar. He said, but for a district attorney, there should be a higher bar, not just by appearance, but there were something to where they could prove, not what they believe, but what they can prove. And I thought that was quite interesting. I'm like, I didn't look at it that way. And let me see, and to prove that there was actual conflict. Now, he cited a court case that was just settled this year, last month, to where the courts ruled that there has to be conflict of interest. That it didn't meet the high level that it should have met, and then it was overturned by a court of appeals. I gotta say, even though that I'm not really impressed with him, he did make out valid points. I think that he could have, I don't know. Okay. There's something about him. But one thing I'm going to say about Fani is this. She was talking about not us smearing a black man, you know, black this, black that. I found it quite interesting that because she's all pro-black, where was her black attorney? Now, I know, you know, some black folks are jumping on me saying I'm a MAGA. No, I'm an independent. I'm an equal opportunity offender. I offend both sides. Okay? I'm looking at where the information is. Where does the evidence lead to? I gotta say, Fani, she's giving Donald Trump a knuckle fight. She's taking him to down. She's. I gotta give it to her because she's most definitely hammering them on procedure because they were not following procedure, and I gotta say, this is an excellent distraction. An excellent distraction. If there's something going on in the world, which there is, and that there are powers to be that do not want us to look at what's going on out there, this is a damn good one. It is good. Trump, you have met your match. She's going to fight you all the way down. She's going to fight you all the way down. How can I say this? She'll go as low as you go. And I gotta say, blue suede boots, most definitely. The merchants, oh, you gotta he pointed out Terrence Bradley being disgruntled, a disgruntled employee, well, not employee, but a disgruntled partner. Because he was being touchy, feely. He was costing Wade money. He had to bail out. Okay, well, we had an assistant attorney, and look, it seemed like Bradley didn't care of the gender. He was just touchy, feely. He was an equal opportunity offender, allegedly an equal opportunity offender. Man, this is gonna be a good one. I gotta say, the merchants, you better do better. Blue suede shoes, boots, you better up it because she's coming after you. On that note, before I go, look, please like, subscribe. That is for free. I'm trying to get to I'm trying to get to 5,000 subscribers. Please help me out there. That's my next goal, 5,000 subscribers. Or double press on the subscribe and like it. And then if you don't like it or dislike it, either way it helps the algorithm. Help me out. And then if you don't like it, I'm going to look and say, okay, maybe there's something I'm doing wrong. Maybe I might want to adjust this or that. That right there is an indicator to allow me to know if I'm doing good, bad, or this way. And on that note, I want to thank you for stopping by.